Hello, everybody, and welcome to another episode of Casual Audio Papers. Today, I'm sort of wanting to get started a little bit on critical race theory because I've talked a little bit about it, and I'm going to be doing a bit more study on the issue because, of course, you never want to be ill-informed when you discuss a topic. And so, in Kimberly Crenshaw's book, Critical Race Theory, the Key Writings That Formed the Movement, he begins by saying that, he begins with a 32-page introduction to the theory, basically saying that there are as many critical race theories as there are critical race theorists, but also it's very, 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 very important. But in the introduction to part 1, Intellectual Precursors, Early Criticism of Conventional Civil Rights Discourse, he talks about the Supreme Court's opinion on Brown v. Board of Education, which is basically, when it comes to traditional liberalism, is like the sacred text, so to speak. Although it's not. It's just a culmination of earlier Western writings on liberalism, civil rights, human rights, and all that sort of stuff. But I have never read it before. And so I think it's really pertinent when you discuss something that is criticizing something that you actually know what they're criticizing. And so that's what I will be reading today. So let's get started. Supreme Court of the United States. This is just in the National Archives. Brown v. Board of Education, 347 U.S. 483, 1954, USSC+. Argued December 9th, 1952. Re-argued December 8th, my birthday, 1953. Decided May 17th, 1954. Appeal from the United States District Court for the District of Kansas. Syllabus. Segregation of white and... I'm going to get in trouble already. Segregation of white and Negro children in the public schools of a state solely on the basis of race, pursuant to state laws permitting or requiring such segregation, denies to Negro children the equal protection of the laws guaranteed by the 14th Amendment. Even though the physical facilities and other tangible factors of white and Negro schools may be equal. A. The history of the 14th Amendment is inconclusive as to its intended effect on public education. B. The question presented in these cases must be determined not on the basis of conditions existing when the 14th Amendment was adopted, but in the light of the full development of public education and its present place in American life throughout the nation. C. Where a state has undertaken to provide an opportunity for an education in its public schools, such an opportunity is a right which must be made available to all on equal terms. D. Segregation of children in public schools solely on the basis of race deprives children of the minority group of equal educational opportunities, even though the physical facilities and other tangible factors may be equal. E. The separate but equal doctrine adopted by Plessy v. Ferguson, 163 U.S. 537, has no place in the field of public education. F. The cases are restored to the docket for further argument on specified questions relating to the forms of the decrees. Let me just reread that first paragraph. Permitting to require such segregated children the equal protection of laws guaranteed by the 14th Amendment. So that's interesting. So this is actually argued on the basis of the 14th Amendment, which, if I remember right, was the... what did it say? Let's go to... It'd be really good to read it. Amendment 14, overview, due process of law. Okay, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. So I suppose it'd be this first clause. And the second clause. Second sentence. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. Okay, so I was thinking of the due process clause, but I'm like, that's not the only part of it. Yeah, so this is equal protection and equal rights of life, liberty, and property, and then, of course, no state shall make a law which abridges not only rights but privileges and immunities of citizens. And this applies to everybody who's subject to the jurisdiction of the United States, born or naturalized. Okay, so that's what that's talking about. Opinion. Mr. Chief Justice Warren delivered the opinion of the court. These cases come to us from the states of Kansas, South Carolina, Virginia, and Delaware. They are premised on different facts and different local conditions, but a common legal question justifies their consideration together in this consolidated opinion. In each of the cases, minors of the Negro race, through their legal representatives, seek the aid of... I really feel like I should be using like a southern accent for this. Oh, man. Seek the aid of the courts in obtaining admission to the public schools of their community on a non-segregated basis. In each instance, they had been denied admission to schools attended by white children under laws requiring or permitting segregation according to race. This segregation was alleged to deprive the plaintiffs of the equal protection of the laws under the 14th Amendment. In each of the cases other than the Delaware case, a 3-judge federal district court denied relief to the plaintiffs on the so-called separate but equal doctrine announced by this court in Plenty v. Ferguson, 163 U.S. 537. Under that doctrine, equality of treatment is accorded when the races are provided substantially equal facilities, even though these facilities be separate. In the Delaware case, the Supreme Court of Delaware adhered to that doctrine, but ordered that the plaintiffs be admitted to the white schools because of their superiority to the Negro schools. Okay. So basically what's happening, and I'm just repeating this for my own sake so I know what's going on, it seems like the Plessy v. Ferguson case is basically a more hands-off approach to the federal government, and they're saying that even if you want to have separate but equal, okay, that's fine, so long as it is actually equal, so long as the facilities are actually part of the, as long as the materials within the facilities and the opportunities provided are actually equal. So if under Plessy v. Ferguson, that doctrine fulfilled the requirements of the 14th Amendment, and this opinion is arguing that that is not the case, that when it talks about equal protections to fulfill your rights and privileges in the 14th Amendment, it's not just saying that they must be separate but equal, like you can make it separate but equal, but people have to have equal opportunity to enter into a particular school, not just that this school and that school are equal. And so that seems to be what they're arguing so far. The plaintiffs contend that segregated public schools are not equal and cannot be made equal, and that hence they are deprived of the equal protection of the laws because of the obvious importance of the question presented. The court took jurisdiction. Argument was heard in the 1952 term, and re-argument was heard this term on certain questions propounded by the court. And so I imagine the criticism might be, well, certain communities are poorer and therefore don't actually have equal access to these schools, and so there has to be some sort of remediation involved. Although I guess you have to sort of find the balance between overreach with the federal government and I guess impotence of the federal government on this issue. The plaintiffs contend that segregated public schools are not. Presented the court. Okay. Re-argument was largely devoted to the circumstances surrounding the adoption of the 14th Amendment in 1868. It covered exhaustively consideration of the amendment in Congress, ratification by the states, then existing practices in racial segregation, and the views of proponents and opponents of the amendment. This discussion and our own investigation convince us that, although these sources cast some light, it is not enough to resolve the problem with which we are faced. At best, they are inconclusive. The most avid proponents of the post-war amendments undoubtedly intended them to remove all legal distinctions among, quote, all persons born or naturalized in the United States, end quote. Their opponents just as certainly were antagonistic to both the letter and the spirit of the amendments, and wished them to have the most limited effect. What others in Congress and the state legislatures had in mind cannot be determined with any degree of certainty. I imagine, this makes a lot of sense according to the 14th Amendment. I imagine if you want to criticize integration and go back to separate but equal, just in a real way, separate but equal cannot fulfill the 14th Amendment. So if you want to go back to separate but equal, you'd actually have to undermine the 14th Amendment to some degree, or even just get rid of it. And so that's going to be, I think, an issue, a pretty big issue that the proponents of critical race theory, if they are criticizing Brown v. Board, they're going to have to overcome that somehow. And I'm not entirely sure how they will without devolving into either racial segregation or even producing the opportunity for slavery again. So we'll see. An additional reason for the inconclusive nature of the amendment's history with respect to segregated schools is the status of public education at that time. In the South, the movement toward free common schools, supported by general taxation, had not yet taken hold. Education of white children was largely in the hands of private groups. Education of Negroes was almost non-existent, and practically all of the race were illiterate. And that's saying in 1860 somewhere, 1868. In fact, any education of Negroes was forbidden by law in some states. Today, in contrast, many Negroes have achieved outstanding success in the arts and sciences, as well as in the business and professional world. It is true that public school education at the time of the amendment had advanced further in the North, but the effect of the amendment in northern states was generally ignored in the congressional debates. Even in the North, the conditions of public education did not approximate those existing today. The curriculum was usually rudimentary. Ungraded schools were common in rural areas. The school term was but 3 months a year in many states, and compulsory school attendance was virtually unknown. As a consequence, it is not surprising that there should be so little in the history of the 14th Amendment relating to its intended effect on public education. So basically, one of the, and we talked about this when I looked into the Scalia opinion on Roe v. Wade, the leaked one. In order to determine what an amendment means, there has to be some sort of history involved in that. And so, for instance, with the 14th Amendment, a major issue with the Roe v. Wade opinion is that throughout American and English common law history, there was never widespread acceptance, even after the ratification of the 14th Amendment, but certainly before, that there's never widespread acceptance that abortion was included in that sort of thing. And so in order for the 14th Amendment to say that abortion is included as a right, there has to be an actual amendment to the 14th Amendment saying that abortion is included in that. You can't just sort of legislate by decree as the Supreme Court on that sort of issue. And so what they're saying here is because when the 14th Amendment was ratified and there was like absolutely no real comparison between the schools in 1952 and the schools in 1868, like they just were completely different animals, then what you have to say is we don't really know exactly what the 14th Amendment was protecting when it comes to schools. And so what we have to do is use the idea that, of course, black and white people are equal, and they have all of the same potential, and therefore they are accorded equal rights to, let's say, schooling, which will help to bring out and fulfill their potential. That's what I'm getting out of it so far. In the first cases in this court construing the 14th Amendment decided shortly after its adoption, the court interpreted it as prescribing all state-imposed discriminations against the Negro race. The doctrine of separate but equal did not make its appearance in this court until 1896 in the case of Plessy v. Ferguson, supra, involving not education but transportation. American courts have since labored with the doctrine for over half a century. In this court, there have been 6 cases involving the separate but equal doctrine in the field of public education, in Cumming v. County Board of Education and Gong Lum v. Rice. The validity of the doctrine itself was not challenged. In more recent cases, all on the graduate school level, inequality was found in that specific benefits enjoyed by white students were denied to Negro students of the same educational qualifications. Missouri ex rel. Gaines v. Canada, Sipuel v. Oklahoma, Sweet v. Painter, McLaurin v. Oklahoma State Regents. In none of these cases was it necessary to re-examine the doctrine to grant relief to the Negro plaintiff, and if Sweet v. Painter, supra, the court expressly reserved decision on the question whether Plessy v. Ferguson should be held inapplicable to public education. In the instant cases, that question is directly presented. Here, unlike Sweet v. Painter, there are findings below that the Negro and white schools involved have been equalized, or are being equalized, with respect to buildings, curricula, qualifications, and salaries of teachers, and other tangible factors. Our decision, therefore, cannot turn on merely a comparison of these tangible factors in the Negro and white schools involved in each of the cases. We must look instead to the effect of segregation itself on public education. In approaching this problem, we cannot turn the clock back to 1868 when the amendment was adopted, or even to 1896 when Plessy v. Ferguson was written. We must consider public education in the light of its full development and its present place in American life throughout the nation. Only in this way can it be determined if segregation in public schools deprives these plaintiffs of the equal protection of the law. Today, education is perhaps the most important function of state and local governments. Compulsory school attendance laws and the great expenditure for education both demonstrate our recognition of the importance of education to our democratic society. It is required in the performance of our most basic public responsibilities, even service in the armed forces. It is the very foundation of good citizenship. Today, it is a principal instrument in awakening the child to cultural values, in preparing him for later professional training, and in helping him to adjust normally to his environment, which I would say is probably mostly true today as well. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has overtaken to provide it, is a right which must be made available to all on equal terms. So it seems like he's talking about public schools and not quite private schools. So I wonder, is there a Supreme Court case that takes this opinion and applies it to private schools as well? That'll be an interesting thing to check on. We come then to the question presented. Does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does. In Sweet v. Painter, Supra, in finding that a segregated law school for Negroes could not provide them equal educational opportunities, this court relied in large part on those qualities which are incapable of objective measurement, but which make for greatness in law school. In McLaurin v. Oklahoma State Regents, Supra, the court, in requiring that a Negro admitted to a white graduate school be treated like all other students, again resorted to intangible considerations. His ability to study, to engage in discussions, and exchange views with other students, and in general to learn his profession. Such considerations apply with added force to children in grade and high schools. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. The effect of this separation on their educational opportunities was well stated by a finding in the Kansas case by a court which nevertheless felt compelled to rule against the Negro plaintiffs. Segregation of whites and colored children in public schools has a detrimental effect upon the colored children. The impact is greater when it has the sanction of the law, for the policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. A sense of inferiority affects the motivation of a child to learn. Segregation with the sanction of law, therefore, has a tendency to retard the educational and mental development of Negro children and to deprive them of some of the benefits they would receive in a racially integrated school system. Whatever may have been the extent of psychological knowledge at the time of Plessy v. Ferguson, this finding is amply supported by modern authority. Any language in Plessy v. Ferguson contrary to this finding is rejected. We conclude that, in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs and others similarly situated for whom the actions have been brought are, by reason of the segregation complained of, deprived of the equal protection of the laws guaranteed by the 14th Amendment. This disposition makes unnecessary any discussion whether such segregation also violates the Due Process Clause of the 14th Amendment. So he's basically saying the first clause in the 14th Amendment makes this clear, and the Due Process Clause, so the latter clause, is not really in view at this point. because it doesn't add anything to the conversation. Like, they have equal rights, and then those rights cannot be taken except by due process. So the question is whether or not they have equal rights. And then you could say, well, can those rights be taken except for due process? And the answer is no. And so the second part is unnecessary because it doesn't say anything about the type of rights that are afforded in the 14th Amendment, which actually makes a lot of sense because, yeah, that's interesting when it comes to the Roe v. Wade argument, because the Roe v. Wade argument was almost entirely dependent on the due process clause, while Brown v. Board is entirely dependent on the equal rights clause. So, interesting. I don't know what that means necessarily, but it does mean that equal rights should have their weight on the equal rights clause and not on the due process clause. Because these are class actions, because of the wide applicability of this decision, and because of the great variety of local conditions, the formulation of decrees in these cases presents problems of considerable complexity. On re-argument, the consideration of appropriate relief was necessarily subordinated to the primary question, the constitutionality of segregation in public education. We have now announced that such segregation is a denial of the equal protection of the laws, in order that we may have the full assistance of the parties in formulating decrees. The cases will be restored to the docket, and the parties are requested to present further argument in questions 4 and 5 previously propounded by the court for the re-argument of this term. The Attorney General of the United States is again invited to participate. The Attorneys General of the states requiring or permitting segregation in public education will also be permitted to appear as amici curiae upon request to do so by September 15, 1954, and submission of briefs by October 1, 1954. It is so ordered. Together with number 2, Briggs et al. V. Elliott et al., on appeal from the United States District Court for the Eastern District of South Carolina, argued December 9 through 10, 1952. We argued December 7th through 8th, 1953. And number 4, Davis et al. V. County School Board of Prince Edward County, Virginia et al. On appeal from the United States District Court for the Eastern District of Virginia, argued December 10th, 1952, re-argued December 7th through 8th, 1953. And number 10, Gebhardt et al. V. Belton et al. On certiorari to the Supreme Court of Delaware, argued December 11th, 1952. We argued December 9th, 1953. So this is the opinion that critical race theory is criticizing and inevitably will be rejecting. So I know a little bit about what they say. Basically, they say that the whole reason for Brown v. Board was to make white people look good or something like that. And also that integration does not guarantee equality, which again is the issue of overreach or impotence of the federal court. So, that's more of a balancing act. But then, of course, the definition of equality under critical race theory is equal outcomes, which I don't think any state, regime, or government could enforce. It's just impossible. And so it could be that their criticism of Brown v. Board is just because of some sort of utopian fantasy that it does not guarantee, and so therefore they don't like it. I don't know. We will see as we move forward, but this is an interesting opinion, Brown v. Board, and I don't understand how people can criticize it while remaining on Earth, and like without having their heads too far up in the clouds, But we will see. We will see. If you have any questions, let me know. Any comments, concerns, arguments, or whatever. And have a good day. Bye.